Thank you for joining us for today's online talk, which will be starting shortly at 3 p.m. For those of you who have joined us early, thank you for waiting patiently. While we wait for the session to begin, we would like to share a short video about our firm.
I founded the firm in September 1985 with the vision of seeking truth and justice for our clients and not just winning their cases. Over the years, the team has achieved many significant milestones. We are today recognized by the Legal 500, Asia Law Profiles, and Asian Legal Business as a recommended firm in various practice areas. While we have embraced technology to make our services efficient and responsive, we continue to grow on the bedrock of meticulous preparation and hard work, for which there is really no substitute. As legal practice becomes increasingly international, we keep ourselves ahead of the curve with our relationships with lawyers from around the world. Our firm is a founding member of the Legal Lawyers, a growing international network of law firms in 20 Asian and European countries.
We believe in partnering with our clients to protect and grow their business. We achieve this by holding firm to our values of integrity and justice, while giving our best to deliver effective and efficient solutions. Instead of just legal services, we focus on developing great working relationships based on understanding and respect.
We regularly advise foreign clients, including many Chinese investors, and have a ready appreciation for different ways of doing business. In corporate matters, we offer relevant and commercial solutions, often raising issues that clients may or may not have realized before. In negotiations, we believe in facilitating win-win outcomes.
Welcome, everybody. Thank you for joining us for today's online talk entitled Personal Liability of Directors When the Corporate Veil Doesn't Protect You. My name is Jeremiah, an associate here in Marvin Kwai & Associates, and I'll be your moderator for today's session. Before we begin, allow me to briefly introduce our firm and the work that we do. Marvin Kwai & Associates is a mid-sized law firm founded in 1985 by Dato Marvin Kwai. Our able team today consists of 30 lawyers and a support team of 32. Following his retirement from the Court of Appeal bench in 2015, Dato Ma now serves as a consultant with the firm. The firm continues its tradition today of working primarily with SMEs, family businesses. We are a full-service law firm with a corporate department, a dispute resolution department, including litigation, adjudication, and arbitration, a dedicated employment or industrial relations team, and a department focused on servicing the needs of individuals and families. Our practice groups indicate some of our focus areas, which are supported by talents from both our corporate and dispute resolution teams. Today's talk is part of our MWKA online talk series. By way of background, we have been organizing monthly lunch talks at our office since 2013, some of which were also broadcast live. But with the COVID-19 MCO, we have since transitioned to online in order to continue with our objective of sharing knowledge, raising awareness, and encouraging networking for clients, potential clients, and in-house counsel. Before I continue, please be reminded that this talk does not constitute legal advice. Should you require specific legal advice in relation to your matter, please contact us for a complimentary legal consultation. Further details will be provided at the end of this talk. We have two speakers for today. Our speakers are Mr. Joseph Kaur and Ms. Joyce Wong. Mr. Joseph Kaur is a senior associate at Marvin Kwai & Associates. He graduated from the University of Malaya in 2019 and was admitted to the bar in 2020. Mr. Joseph co-heads our land and real estates dispatch team together with our managing partner, Mr. Raymond Ma. Mr. Joseph also is part of our corporate and company litigation team with notable experience in corporate and company disputes. These include acting for company directors in actions brought against them, acting for various parties in derivative actions, corporate insolvency, corporate fraud, and shareholder disputes. Ms. Joyce Wong is an associate at Marvin Kwai & Associates. She completed her bar training course from Cardiff University, Wales in 2022 and was called to the Malaysian bar in 2023. Her areas of practice include medical negligence, constitutional law, defamation, corporate fraud, debt recovery, and contractual disputes. In today's talk, Mr. Joseph and Ms. Joyce will explain the situations where the corporate veil does not protect company directors, thereby exposing them to personal liability. The points which will be discussed include directors' fiduciary and statutory duties, when would courts impose personal liability on directors, regulatory exposure, and practical risk management for directors. Ms. Joyce will speak first regarding directors' fiduciary and statutory duties, and Mr. Joseph will cover the rest of the remaining points. We will conclude our talk today with the Q&A section. If you have any questions, please feel free to type them in the Q&A chat box. We will address the questions at the end of this session. With that, I'll now hand the session over to Ms. Joyce to begin our talk for today.
Hello, everyone. Thank you for sparing your time with us this afternoon. So today what I will cover is the legal part, as in the more boring stuff, and I'll leave the practical impacts and also the real life examples to my able senior Joseph after my top points. So I'll start from the director's fiduciary and statutory duties. So these are the main sections in the Companies Act 2016, which show that how a director should act properly in terms of discharging his or her duty. So the first one is section 213. Essentially what this section is talking about is directors should act in the best interest of the company. So here it says how a director should exercise reasonable care, skill, and diligence with the knowledge, skill, and experience that he or she has. So you will wonder what is the best interest of the company. In this case, it's a federal court case. It says there are two parts to it. So one is objective element, which means any person in that position as a director should act in a certain way to discharge his or her duty. So that duty has to be discharged with the concept in mind that it will be for the benefit of the company. And the second part is a subjective part, which is that the director genuinely and honestly believe that his or her action is in the company's best interest. So there would be situations where directors do make decision and eventually it goes wrong, right? So there would be situation where the director actually doesn't think that it's genuinely in the best interest of the company, but maybe in the general director's mind, it might be something that's doable. So in that case, if the director is shown that he doesn't genuinely believe is the best thing to do for the company, then he can still be liable. Now, I will explain a bit about the difference of directors and shareholders, because there are a lot of, especially family businesses, where directors and shareholders are the same person, right? So the line between their duties are very fine. So this is more applicable in the sense that where shareholders and directors are a different group of people. So directors, what they do is to manage the company, and company and shareholders, they are different entities. So shareholders, of course, they are the paymaster. They are the person who essentially fund the company's activities and financial. But when the directors are carrying out their duties, they have to look at what is in the best interest of the company instead of what is in the best interest of the shareholders. So the next one, I will share the case that I mentioned just now, Dato Ibrahim's case. The facts are, in simple terms, is a dispute between shareholders and directors. So what happened was the company was in financial difficulties. They have cash flow problems. So the board of directors decided to sell off one of their largest shares in a subsidiary company, which they were initially fully owned. Because of that, of course, the main company, which is PEB, get the money from that sell-off of shareholdings, but the shareholders do not own any other share in the subsidiary company. So the shareholder is claiming that there is no resolution passed to make that sales in the first place, and therefore the directors have breached their duty. But what the court decided was, as long as the directors have acted bona fide, which is in good faith, is not in their own interest or personal interest, and is with guidance from experts such as bank or financial managers, then it's a good commercial decision. And if you look at this extract, it actually shows that judges, they are not keen to interfere into commercial decisions, because courts are there to provide justice, and they usually want to leave it to the commercial parties, which are the directors or people who are more experienced in corporate matters to handle their business by their own. Now, the next section is section 214. So it's a bit similar to the previous section. It says a director who makes a business judgment is deemed to meet the requirements as to discharge the director's duty in the best interest of the company. As I've said just now, the court will look at whether there's any personal interest involved and whether the director actually believes that what decision he or she made is appropriate in the circumstances. Now, for section 215, actually I've mentioned that also in the previous case. So the court will look at whether the director has consulted any expert. So let's say it involves a financial problem, whether financial experts or banks are consulted before making a decision. So as directors, it's better that you have backup from experts so that you can explain your decision and also do the best thing for the company. For section 218, it's more about personal interest. So whether the director is trying to use the property of the company for his own benefits. And you will see from this section, subsection 2, it actually imposes a criminal liability instead of just civil liability, as in shareholders or the company bring an action against directors. So there might be a criminal implication, as in you might face a term of not exceeding 5 years or a fine not exceeding 3 million ringgit if you breach this section. So usually this will be brought by the prosecutor through the investigation by SSM. Okay, for section 219 is actually also about not acting in the best interest of the company, but is more specific to certain circumstances. I won't go into detail, but these are the situations where the director might be liable. Now, the next one is fiduciary duties. Actually, it's very similar to what was explained earlier. So these are the duties assumed on a director. So a director, if he is sued, he cannot come to court to say that I don't owe a duty to a company, because it's presumed by the court that directors owe a duty to companies. So he must act honestly and he must have proper purpose for the use of company's assets, and he shouldn't put his personal interest over the company's interest. Now I will pass it to Joseph to explain the real life examples and also how courts actually impose personal liability. So I'll pass it to you, Joseph.
All right. Thank you, Joyce, for explaining the basics of the imposition of personal liability on directors. I will now touch on the more practical aspects of this topic. As explained by Joyce, there are situations where the courts or even the law itself imposes personal liability on directors. So to answer this question at the outset, when do courts impose personal liability on directors? The answer is when the law says that the courts can do so. And I will take everyone through certain situations and scenarios where courts have imposed personal liability on directors. And then I will proceed to share a few tips, a few practical considerations that can be considered by directors from our experience in corporate litigation. Some things to avoid, some things to consider, and some steps and practices that directors or even in-house legal counsel can assist in taking. Now, the most common situation where courts will lift the corporate veil and impose personal liability on directors is where there's situations of fraud. As Joyce has explained earlier, the bedrock of company law is that the moment a company has been incorporated, it is a separate legal entity from the members of the company, the directors of the company. So the company has a personal or a legal existence of its own. Most of us here, in-house legal, come from a legal background and understand this distinction. And my colleague Joyce has also explained it briefly in her segment earlier. But we get a lot of questions on a regular basis saying, can we go after the directors of the company? And the most critical question that needs to be answered is, who did you have that legal relationship with? For example, if you had a tenancy agreement, did you sign the tenancy agreement with the individual or with the company? If it's with the company, then your recourse or your legal action must be brought against the company. Now, I will come and touch on certain situations where you can go after the directors shortly, but the general rule is that the company is the one you have to go against. You may think that this is a very common principle and everyone knows it, but we still do get a lot of questions on this. If there's no written contract, your correspondence with the other part in their capacity as a company or in their capacity as an individual. Sometimes these lines are blurred when it comes to SMEs, small, medium businesses, where the individual is one of only a handful of employees or officers in the company. All right. So the key point to note is if it is in the capacity of the company, meaning your legal relationship is formed with the company, the person to go after is the company, except in the situations where we will describe shortly. In most cases where the courts lift this corporate veil, so what we describe is called a corporate veil, fraud is involved. Now, there's been cases in the past that have dealt with issues of whether there is the test of single economic unit, whether the courts look at these several entities as a single economic unit, but the recent federal court's decision in Shaw has clarified that is the old position, all right? So the central theme or the central line that you see running through all the cases when the corporate veil is lifted is that there is fraud involved. Fraud is a general and broad category. A lot of things can be considered fraud, but most importantly, what the courts look at is the fraudulent intention. For example, a real life example is, I'm not sure whether anyone has read this news article, where the High Court has found a travel firm and 3 directors liable for 400 and about 500,000 Umrah fraud. So what happened was that the sum was meant to cover the pilgrim's flight and Umrah packages, but it was used by the directors for personal reasons. As explained by Joyce earlier, a director cannot be in a position of conflict with the company, cannot use the company for his personal benefits. And the fiduciary duty demands that it be in the best interest of the company. If I, as a director, use monies that come into the company by way of payments, whether from customers or otherwise, and I use it for my personal gain, I use it to fund my personal holiday to the Maldives, that is a breach of my fiduciary duties to the company. But if I use that money and transact it for a business transaction for the benefit of the company and not myself, then I'm in the clear. So where there is fraud involved, where there is siphoning of company funds, or where the company is used to deceive a third party, to cheat a third party, for example, like customers, to cheat suppliers, then the court will lift the corporate veil and impose personal liability on the directors. That is the one that we see, one of the most common things we see where the courts impose personal liability on directors. The second is in oppression actions and derivative actions. These are technical legal terms. The difference is that an oppression action, the minority, most of the time, the minority shareholders are saying that the majority is misusing their power to oppress the minority. And among the remedies that are available to the minority that has been oppressed is an order for share buyback, adjunctive relief, or winding up of the company. But in the case of Auspicious Journey, the court clarified that legal personal liability can also be imposed on the directors, meaning the directors can also be ordered to pay damages, although that did not happen specifically in the case of Auspicious Journey. Now, the facts are slightly complicated and I don't want to go into it. It involves like options, and that is another can of worms by itself, options, contracts, and all that. But the takeaway really is that if a director is involved in an oppression action, and that oppression action involves these few elements, the court can order the director to be personally liable, even in cases of shareholder oppression. So there's clear evidence of their deliberate involvement or participation, oppressive conduct. It is objectively fair and just to impose liability on the directors. The punishment or the imposition of liability goes no further than necessary to stop the oppression or fix the breach. And the imposition of liability must be reasonable to alleviate legitimate shareholders' concerns, and it must not be used merely as a substitute for other statutory or common law relief. So that is number 2. In shareholder oppression actions. The third is in derivative actions. So just to briefly give some context as to what these two are. Oppression actions are where a wrong is committed against a minority shareholder in its personal capacity. For example, the majority are targeting the minority shareholder and not giving them the dividends that are due to them, or denying the minority shareholder of access to documents that they have a right to. These are personal claims by the minority shareholders. A derivative action, on the other hand, is wrongs committed against the company. So, for example, a shareholder finds out that the directors or the majority, sometimes in smaller companies, it's both, are using the company for ulterior motives, for their personal interests. In such situations, this shareholder can ask for permission from the court to bring an action against the director to hold that director liable. And that director must, of course, make reparations to the company. So let's say if the director has misappropriated funds of 1 million ringgit, the court will order, if the director is found in the wrong, the court will order that the director pay the company, not the shareholder, not the minority shareholder, pay the company damages, 1 million ringgit, aggravated damages, so on and so forth. So in this case, which more people will know, an independent director seeks legal action against the directors and management of a company for alleged breaches of fiduciary duties. Fiduciary duties are what my colleague Joyce has explained earlier. Now, the fourth situation that I will touch on, where the courts will not hesitate to impose personal liability on directors, is where personal guarantees are given. So if you recall my example earlier on the provision of your legal relationship, let's say you have an agreement, a supply of goods agreement with a supplier. And the supplier, the contract is between your company and the supplier's company A and company B. So you are the supplier company. So you supply goods to this counterparty, you supply goods to company A. And one day company A stops paying. And you found out that company A no longer has any funds. The company A is basically going to close shop. In those situations, you sue company A, you get a judgment. And if company A does not have the funds to pay your company for the supply of goods, you can wind up company A, yes, but there are literally no funds left or close to no funds left to satisfy your debt. So what do some companies do? Some companies will make company A's directors sign personal guarantees. All right, say, I enter into this agreement with you to supply a huge amount of goods. Of course, the company is liable to pay me back. But on top of that agreement, I make their directors sign a personal guarantee to say that if the company fails to pay you, I as a director will be personally liable to make payment on behalf of the company. So we have handled several cases where the courts, when they see that there's a personal guarantee by the director, then yes, the courts will impose the liability on the directors. So not only is the company liable to pay, so I supply you goods worth 1 million ringgit. I supply, the company doesn't pay me. I sue both the company and its directors that signed the personal guarantee to say that you and your directors that signed this personal guarantee are liable to pay me this 1 million ringgit. So even if the company cannot pay me this 1 million, I can go after the assets of these directors because they have signed a personal guarantee. Of course, the practical aspect of this is that when it comes to contractual bargain, there's always people with higher bargaining power and lower bargaining power. You can't always force the other side to sign personal guarantees. But where you do, this is the options, and the courts will not hesitate to impose personal liability on the directors where personal guarantees are given. All right. So the general principle here, basically in Bank Pembangunan's case, is that the court will honor the personal guarantee. That's it. Long story short. So that's the fourth situation. There are more situations. It's not exhaustive. There are regulatory exposures, which I will come to, where you don't have to go to the courts. For example, there are certain tax implications. So if the director tries to structure the income in such a way, the Income Tax Act empowers the tax authority to impose personal liability on the directors. But that is a huge can of worms, and we don't have the capacity to deal with that in our talk today. These are the implications statutorily that Joyce has mentioned earlier, and these are fines for implications. These are criminal liabilities that are imposed directly on directors. Criminal offense for a term not exceeding 5 years, not exceeding 3 million, both when there's a contravention of this. So where there is a breach of fiduciary duties, not only is there civil exposure as a director, meaning my shareholders can sue me in the name of the company. My business transaction counterparts can sue me if there's fraud involved. The state can also bring criminal prosecution against me if I breach such duties under the companies. One example is in the case of the public prosecutor against Teo Zixin, where two directors misused their position and paid 200,000 ringgit as bonus to themselves. They each pleaded guilty to breach of Section 218 and was fined 100,000 each to be paid, failing which 6 months of imprisonment. The main thing there is also the bottom line. Is the director's actions in the best interest of the company, or is the director's actions in the best interest of themselves? That's the bottom line. That's what is always asked in all cases. In this case, the court found that in Yu Xing Lin's case, the court found that the director breached Section 219 and 221, conflict of interest, by failing to disclose to the board of directors his personal interest in two outside companies. And because of these undisclosed companies were acting as suppliers and conducting business for a sizable sum within the very company he was directing. So when it comes to big companies, you have subsidiaries and company transactions between these, your holding company, your subsidiary companies and related companies. You need to be careful you need to be careful to disclose any interests to the board. You need to be careful to make sure that the transactions are in the best interest of the company. You need to be director of the holding company to act in the best interest of the holding company. The director of the subsidiary must act in the best interest of the subsidiary to ensure that everything is taking place so that all your risks are covered. Not only are there liability implications in terms of imprisonment, monetary consequences, there's also other soft or consequences that are not immediately tangible, which we have come across in assisting our clients over the years. For example, a disqualification from acting as a director if you are found in breach of fiduciary duties. Reputational and career consequences, that goes without saying, especially if you're a director of a listed company. Loss of indemnity or insurance protection is another that is possible. An example is the collapse of the UK construction giant. Regulators invested the conducts of its directors. This is one that maybe a lot of you will be aware of. So two former executives accepted director disqualification undertakings. So this is the UK. Carlos Ghosn was once regarded as an influential automotive executive, leading Renault, Nissan Motor and Mitsubishi. The events following his arrest in 2018 demonstrate how governance breaches can destroy a director's career even before final legal outcomes are reached. So these are examples that we see in the news. These are examples, news that we hear of. The same can be said in Malaysia as well. So these occurrences are not isolated to directors overseas, but are rather applicable across the board. Specifically under Malaysian law, there are certain persons that are disqualified from being a director. So under Section 198 of the 2016 Companies Act, a person cannot hold office of a director if he has been convicted of an offence relating to the promotion, formation, or management of a corporation, has been convicted of an offence involving bribery, fraud, or dishonesty, has been convicted of an offence under Sections 213, 217, 218, 228, and 539 of the Companies Act, or has been disqualified by the court under Section 199. So you will see here, mostly it relates to criminal conviction. So does that mean that if there is no criminal conviction, so there's a breach of fiduciary duties and there's civil liability, but there's no criminal conviction, a person is not precluded from holding an office as a director of a company? The answer is yes and no. Strictly speaking, if we just look at what is prescribed by the law, then no. If it's just civil liability, you're not necessarily precluded from being a director of a company, at least insofar as private limited companies are concerned. That's fine. You're okay. But under Section 119, the court may, on an application by the registrar, make an order to disqualify a person from acting as a director if within the last 5 years, the person has been a director of two or more companies which went into a liquidation, meaning winding up, or colloquially speaking, bankruptcy, from the company being insolvent due to its conduct as a director, which contributed wholly or partly to the liquidation. So, in other words, if you did a bad job within the past 5 years, and within the past 5 years, two of the companies of which you are a director went into liquidation, went bankrupt, the registrar or SSM registrar can make an application to court to disqualify you from holding a position as a director of a company. The registrar can also make this application if you contravene your duties as a director, or due to habitual contravention of the Companies Act. So this is not limited to criminal liability only. It also extends to civil liability, but although not as direct, it's on the application by the registrar or SSM. All right. So what happened in those international cases is showing us that remedial actions can be taken, and the remedial actions as shown here can help in damage mitigation when it comes to reputation of the company. But the directors, of course, got it quite bad. And it is not uncommon for insurance policies or insurance service providers to limit or exclude coverage for fraud or dishonesty, intentional misconduct, personal profit, statutory liabilities, and fines and penalties imposed by regulators. So that depends on the insurance contract, it depends on the insurance policy, and that is governed purely by insurance policies, the contracts. Now, I will speak for another few moments on regulatory exposure and practical risk management for directors. Another common issue that we see being faced by directors, especially in small, medium enterprises, especially in small companies, is failure to lodge annual returns and financial statements and directors' reports. One story that we hear on a very regular basis is that the director comes to us, say, I'm very busy running the company and I forgot, or I just didn't have the time, or I just didn't bother to get the annual returns done, financial statements and directors' reports lodged. A lot of this happened during the COVID pandemic, but since that is far behind us, it's becoming less common, but we still hear it. All right. Failure to lodge these statutory documents may result in a fine up to 50,000 ringgit and a further fine not exceeding 1,000 ringgit for continuing offence after conviction. If the registrar thinks or SSM thinks that because you're not lodging your returns or financial statements, usually they use that to conclude that the company is not carrying on business or not in operation. And SSM can strike off the company from the register. It may seem like a small thing, but if the company has continuing businesses that are ongoing and it ceases to exist, meaning it's struck off the register and ceases to exist, it could have heavy legal implications for the contracts, for the deals, for the business operations of the company, because you can't transact with a company that does not exist, right? Whilst usually most of this heavy lifting here is done by the company secretary and the company's accountants, sometimes the directors just didn't get around to signing off on those documents, despite several reminders. So we need to be very careful. It may seem like a simple thing, rookie mistake, but we see it all the time. Of course, when it comes to listed companies, there are another whole can of worms and rabbit holes we can go under to look at Bursa listing requirements, the Capital Markets and Services Act. But essentially, when it comes to a breach of the listing requirements, breach of the Capital Markets and Services Act, directors can be personally liable for reprimand, public reprimands, and trust me, you don't want to get that, even though there's no money involved, directly, fines, compulsory training courses, or even imprisonment when it comes to breach of the main Capital Markets and Services Act itself. For example, this is one of the reprimands that we can extract from Bursa Malaysia, and see Bursa Malaysia Securities publicly reprimands and fines this company and 2 directors. You wouldn't want your name to be there, just to say the least. So here are a few recommendations or suggestions that we would give to directors as good practices to maintain to avoid personal liability. Number 1, maintain regular board meetings with proper agendas. Ensure board minutes are accurately recorded and deliberations and dissents are accurately recorded. Point number 1 and number 2 relates to one common issue that we see with a lot of companies where shareholder disputes are concerned. That is the lack of documentation of board meetings, lack of documentation of approvals given. Sure, we have the resolutions, but what is the deliberation that happened before the resolutions were passed? When there's a shareholder dispute, when there is a suit for oppression, when the exercise of your fiduciary duties are being questioned, the resolutions don't say much. We have to look at the board meetings, the minutes, and deliberations to see whether or not these deliberations were being discussed, whether any conflict or potential conflict of interest was highlighted to the board, whether there are any risks that should have been highlighted that were not highlighted to the board. All this can play into whether a suit succeeds or fails against a director for breach of fiduciary duties. Especially when it comes to companies that joint ventures. Joint ventures between two companies. So your shareholders are not individual persons, your shareholders are companies. And when board meetings are not properly recorded and disagreements arise, that's an issue. It always becomes an issue. Communication always becomes an issue. Don't need to go to court if only the deliberations, if only the documentation was properly kept. Number 3 and number 4 is establishing board committees when necessary. Audit, risk, or remuneration is concerned. Ensure clear separation between board oversight and management functions. This basically is some ways to, or some suggestions to make oversight and deliberations more robust, making things more solid. So we recommend always to declare interest promptly in any transaction involving the company. If, let's say, you are dealing with a company that is owned by a close relative of yours, it should be declared during the board meeting. If you are even in a small company, because you never know who is going to buy, you may want to sell your company later. You may want to sell your shares 1 or 2 years down the road. And when the new board takes over and see that these things have been done, they may still come after. So even in smaller companies, declare interest in board meetings, in circulars, to say this is a related party. Refrain from participating in board discussions or voting on conflicted matters. Participating, that's still okay. You may want to refrain from voting on matters that you are conflicted on. So let the other members decide. Ensure disclosure is recorded in board minutes. So this is very important. This has basically been covered by Joyce earlier. Yeah, so some practical safeguards would be to implement approval procedures for director-related transactions, ensure independent board approval for related third-party dealings, maintain clear policies on corporate opportunities. So the directors should ensure that the company has proper internal financial controls, regular compliance reviews, documented risk management policies, and internal audit functions. I think this one goes without saying. And when it comes to administrative tasks, which can be a bore, which can be cumbersome, directors must also ensure you can delegate, but you must make sure that it's done. Timely filing of annual returns, proper financial statements, accurate statutory registers or up-to-date statutory registers, and compliance with statutory disclosure obligations. When you need to question management decisions, you should request additional information when necessary and avoid blindly relying on dominant shareholders or executives. The courts have held that even non-executive directors have a fiduciary duty to the company. That duty, of course, is not as high as executive directors. All right. So if you are a sleeping partner, if you are a sleeping director, when you need to play your role, you need to ensure that you are doing it for the best interest of the company and it is recorded. This is to avoid you being caught up in a situation where the executive directors are doing something and you didn't care, you just let them do whatever they want without raising any objections. The court can hold that you are implicit in this, for example, in a fraudulent transaction. So as an independent or non-executive director, you also need to protect yourself in the sense that you need to make sure that appropriate objections are raised, appropriate questions are asked during board meetings where you're involved. And when facing complex transactions or regulatory issues, we would recommend that you can obtain advice, let's say legal issues from lawyers, accounting issues from accountants, financial advisors, and external subject matter experts if not available in-house. For example, if you're not a company that is familiar with construction or real estate, for example, obtain independent reports from surveyors, engineers, architects, town planners, so that the members of the company can't say that you're making rash, urgent decisions that are in violation of the business judgment rule. All right. That's all from me. I think it's time for questions, but we'll have a look if there are any. Jeremiah, over to you.
Thank you, Mr. Joseph and Ms. Joyce, for your valuable insights on today's topic. We will now take questions from the participants from the Q&A chat box. The first question will be for Ms. Joyce, and it's from an anonymous person. The first question is, let's say the company did purchase the insurance for the directors, and the company is supposed to conduct an AML screening subscription, but did not do so. They didn't invest or support AML screening subscription. So end of the day, none of them liable. Is that right? If they get penalized by BNM, insurance company would pay off.
Thank you, Jeremiah, for the question. So firstly, it's under the Anti-Money Laundering Act that it is mandatory to have this screening involved. So customer due diligence, right? So if it is not done, so here, just now I heard a question saying that if the company didn't do it, but the question is, who is behind the company not doing it? Is it the management? Is it authorized by the directors? So the company may be penalized by B&M, and at the same time, the directors might be liable as well if there is evidence to show that the director actually authorized these kind of things to happen in the company. And there is a section in AMLA Act to say that it is for the director to discharge his burden to show that he didn't consent to it or there's no authorization on his part. So the general rule will be if the company is liable, then the director is likely to be liable. In terms of the second part of the question for insurance coverage, for this kind of regulatory breach is very unlikely to be covered by the insurance policy. But of course, we need to go through the policy to see whether it's covered or not. But I would say usually the insurance company, they do their own diligence. They know these kind of things shouldn't be covered. And so it will, in any event, if the director is liable, then it will be a personal liability on their part. Jeremiah, is there any question? Maybe you can pose.
Thank you, Ms. Joyce. For the next question, this is from Ms. Nurul Hidayah Matnase, and this is for Mr. Joseph. Does oppressive conduct refer to internal oppression in the company only?
Yes, because I would assume that you are asking this question in the context of our presentation. So in the context of our presentation, the oppressive conduct refers specifically to a category of actions called shareholder oppression. So it is oppressive conduct, not internal. The more accurate way to say it is that most of the time, the majority is oppressing the minority shareholders of the company. So yes, in those kind of situations, directors can be held personally liable in the circumstances that we have explained earlier. But this is rare. Most of the time, the remedies will be share buyback. So if the court finds that there is oppression, the court will order that the majority or the wrongdoing party buy back the shares of the innocent party, or the court say it's better to just wind up the company. Since I see questions and this, I'll just take the next one as well. An anonymous attendee has stated that even when there's personal guarantee with the director, in the end, it's still very challenging to recover the debt from the directors at court. If the directors themselves also have no funds to pay, then yes. But we have done cases where, because the court has given judgment against the directors in their personal guarantee as well, the directors are more concerned and will find ways to make payment of the debt as opposed to if the judgment is just against the company. Because if the debt is against the directors personally, they can become bankrupt. And the implications of bankruptcy on an individual directors is quite high. The toll is quite high. So if judgment is entered against a director, they would do all they could to avoid bankruptcy against them. So in these cases, a lot of times what we see is that once judgment is entered, even if the company has no funds or the directors don't necessarily have the most funds, they will find ways to enter into some sort of settlement with you. Say, okay, I get it. You don't bankrupt me. I will make arrangements to pay your debt, either by installments or some sort of alternative arrangement or whatever. So it makes your bargaining power or it makes your enforcement power stronger when there's a personal guarantee. I think Hannah asked, is it necessary for board meetings if the company is really small? The theoretical answer is yes. The practical answer we see is a lot of times decisions are made via WhatsApp communication. That could be fine as long as you have your statutory meetings, like your annual meetings and all that in accordance with the Act. So a lot of decisions, as long as the paper trail can be shown if it goes to court. Of course, in the ideal world, everything will be recorded, meetings, everybody come and sit down, and there will be emails or written, printed papers exchange, emails exchange, but that's not the commercial reality. We all know that. But as long as there's a paper trail to show that conflicts have been raised, as long as the paper trail to show that conflicts of interest have been raised, risks have been raised, and the directors have deliberated it, then you should be in the clean. The most important point, the takeaway would be documentation. Documentation does not need to be written, does not need to be printed, but it should be written. What about nominee directors who have no knowledge about the operations of the company? Nominee directors, so in the eyes of the law, all directors owe fiduciary duty, whether you're nominee directors or you're a sleeping director. But of course, as explained earlier, when it comes to sleeping or nominee directors, the duty is not as high as an executive director. But you need to show that you are acting in the best interest of the company. So you need to ask the appropriate questions. You still need to do your duty to make sure that the affairs of the company, as far as your supervision allows, is being done in a manner that is the benefit of the company. So yes, there is still a duty. The law still imposes a duty on nominee directors, although not as heavy. So in other words, to put it plainly in plain English, the court will be more lenient on you. The court is less aggressive to say you are personally liable, but that does not mean you don't have a duty as a nominee director. So I'm just looking at to see whether we have more questions. If a company has one director and one shareholder who are the same person, how to comply with the section in the Companies Act? Mainly for small companies like this, make sure that your statutory documents are lodged. Make sure your company secretary is doing a good job and lodging all the documents on time. Then you should be fine. Okay, that's been answered. What is the legal document to protect, indemnify on appointment of nominee director? You can get a legal document from the other directors to indemnify you. So an indemnity is certainly something that you can get. But that does not reduce the fiduciary duty of the director. So you can have a document, you can have an agreement with, I don't know, if within the shareholder agreement or within whoever appointed you to say that if I get implicated, you are going to indemnify me. But that's a two-step process. So you will kena your liability and then you go and sue this other person for indemnity. It's a two-step process. But our recommendation is to not get there and do your job properly, or at least exercise proper supervision to ensure that it does not get there. So yes, an indemnity can be signed, but that does not absolve a director of the director's duties. It just gives an avenue for that director in the event they are found liable to go after someone else to compensate them. Okay, I think we'll take one last question. If the company is managed by a couple but only registered under one person's name, the other has been involved in the company and transferring out monies from the company, can the director take any actions against this other person to demand for the monies? Is it necessary to prove that they are de facto director? No, it's not necessary to prove that they are de facto director. It can be taken as an employee of the company. If, let's say, an employee of the company is siphoning out company funds, the company can sue the employee of the company. That is not necessary per se to establish that that employee is a de facto director. The legal provisions and the intricacies, the nuances will differ. But to answer that question, not only directors are liable for company, employees can also be liable for wrongdoing. So if you are an employee and you're siphoning out company funds, the company can sue you for the funds that you're siphoning out of the company. And the directors will probably sign off on the resolution or take the relevant steps anyway.
Thank you, Mr. Joseph and Ms. Joyce, for answering the questions posed. Now we reach the conclusion of this talk. Before we conclude, I have a few announcements to make. First, please join us again for our upcoming talk entitled Strengthening Your Contracts in Uncertain Times, Understanding Force Majeure. This talk will be conducted on 8th of April 2026 and the speakers would be our partner, Ms. Cassandra Nicole Tomasios, and our senior associate, Ms. Anis Muhammad Sohaimi. Secondly, please fill in our feedback form and tell us what you thought of our talk. The link to the form will be posted in the chat. And thirdly, do follow or like our social media accounts, which is shown here in this slide. Fourthly, if you would like to speak with our lawyers, we offer a complimentary consultation up to 30 minutes over the telephone or over video conference. Please fill in the form on our website. The link is posted in the chat box. To our guests, thank you for joining us. We hope you have found today's session informative and useful. Thank you, everybody, and see you at our next talk.